Thanks everybody again for attending. This is our third environmental regulatory update with Don, and he has quite a bit of new information for everybody, so we can get started. Again, if you have any questions or comments, go ahead and jump right in, and we can talk. You can talk to Don specifically about anything that he is going to discuss today.
Yeah, I think that's the best part. If you can raise a question while we're doing the presentation, I have no problem with that. And I think it's also, if you have a question like that, others may have the same question. So don't hesitate to speak up or voice a question. So this is our third presentation, and what I originally intended to do was um, go over key environmental issues that are really foremost in on the forefront of environmental law and environmental practice. And um, and I use a number of different sources. For example, I'm going to go down a brief list, but the I find the DNR Air Advisory Group is really helpful for new information. The Wisconsin Transportation Builders Environmental Committee is really helpful. Uh, a lot of information has come from WMC's Environmental Committee, the NR 700 Advisory Group, the PFAS Advisory Group. So these are all sources of information. One of the things that is really dominant in this week's or this month's presentation is the legislative council's discussion on AB 131 and the substitute amendment. And that has to do with all the grant programs and addressing PFAS. And there are a number of different parties that will benefit from this, including municipalities, municipal landfills, landfills that are privately owned that have municipal waste. So we're going to, there's no way that we can analyze that legislation entirely, but it'll be an introduction to it. And I find it fascinating. It's very complex, and DNR will really have their hands full to implement that program. But over time, I'm sure they'll do a good job. So I'm just going to start out with basically state issues that I think are really relevant and in the forefront, and some federal issues as well. And I'm going to try to touch on cases and to give you a flavor for the litigation surrounding federal legislation, and that creates a lot of uncertainty for the states in terms of what EPA is trying to accomplish in Trump's deregulatory program. I think it's dangerous if companies rely entirely on what Trump is and Lee Zeldin, the head of EPA, are trying to accomplish, because my fear is that all can be reversed with the next president, or even with the midterm elections if the Democrats come in control of the House and Senate. So anyway, moving forward, the first item is a wetland issue, and DOT has created a new form for Section 404 pre-construction notification template. And this is designed to make sure that you provide all the necessary information to the U.S. Army Corps. In Wisconsin, DNR is in control of all wetlands, but the Army Corps is only in control of federally regulated wetlands. So one of the first steps on a wetland matter is to find out whether it's a federally regulated wetland or not. The second item, a DNR, is to petition EPA to revise our ozone non-attainment designation. And this is a huge issue for southeastern Wisconsin. There's currently a case pending in the Seventh Circuit Court of Appeals in Chicago and it has to do with the reclassifying Wisconsin's ozone non-attainment areas from moderate to serious. That is a huge impact on southeastern Wisconsin, and it affects Milwaukee, Ozaukee, parts of Washington, Waukesha, Racine, Sheboygan, and Kenosha counties. That litigation is currently stayed in the court pending EPA's publish of a proposed rule. At this point, the state needs to, I think in June, provide a request and a petition to EPA to proceed with this reclassification. Now, what's instructive is that DNR and EPA will have 18 months after DNR submits the request to make a decision. What's instructive is the next paragraph where EPA has already issued proposed rules for St. Louis and Cleveland. And they did reclassify those areas as serious non-attainment. However, they they accepted a demonstration related to the Canadian wildfires as an exception to the incoming contamination. They also suspended the long-term effects of those that change in regulation. So this is going to be a huge issue for southeast Wisconsin, but we have at least a year and a half to wait on the outcome. In terms of Wisconsin PFAS updates, I mentioned Assembly Bill 131, which is essentially the regulation and the grant programs, and Assembly Bill 130, which is the appropriation of funding. I find it fascinating that the substitute amendment to Assembly Bill 131 basically consumes the rule and modifies it, and I think that was necessary for this to go final and be passed this last spring. So this is a very new rule, and it's part of your handout, and we'll go over it, briefly in a superficial manner, at least. The PFAS drinking water rules is final. It's approved by the governor at the end of February. And what it does is adopt the national primary drinking water standards for PFOA and PFAS. And then, in addition, new MCLs for other PFAS chemicals. And so there are a lot of critics on this and on both sides. And municipal water systems think that the rule is too harsh, and the environmentalists feel that it's too lenient. So we'll see, and there's litigation on this as well. What I find really interesting is that generally the appropriate place for litigation is the District of Columbia Court of Appeals. However, Trump and Lee Zeldin are pretty smart, and they do what's called forum shopping. So they bring some of these cases with DOJ as their attorneys in Texas, where they know it's a strong Republican area, and the judges are appointed by Republicans. So, and you'll see as we go down through these cases, the strategy that the Trump administration and Lee Zeldin are implementing. In terms of PFAS updates, the federal water standards are basically in place, and Wisconsin is adopting those standards. So how does this affect Wisconsin? Clearly, it's not only going to affect our drinking water regulation in our 809, but also our groundwater regulations, because in Wisconsin, we adopt the groundwater standards consistent with the MCL. So the ES in Wisconsin is consistent with the federal MCL, maximum contaminant level. And so we need to watch this closely because Trump and Lee Zeldin are playing with this and adopting certain federal standards, but also rejecting certain standards and saying that there was not a thorough enough evaluation of the risk and impact. This TSCA reporting rule, I think, is a sleeper, and I'm concerned that many people may not be aware of it. But this is a rule that requires manufacturers of chemicals and importers of chemicals to report, and the report has to be the volumes that of imported or manufactured PFAS chemicals from 2011 to 2022. So that's a huge reporting period, and the reporting period is just started April 13th through 2026 through the end of October. So if you're affected by this, or you import or use PFAS chemicals, you may have a reporting obligation. It's only if you directly import or directly manufacture. If you're buying from a supplier, that supplier has that obligation. There's an exception for small manufacturers, but it only moves the compliance date 6 months. And so I wouldn't entirely rely on that. There's new Wisconsin battery recycling legislation, and it doesn't affect automobiles, lead acid batteries, or the normal battery recycling program, or even the e-cycle program for electronic waste. But what it does is it deals with rechargeable lithium-ion batteries and the batteries that are causing fires. It's in certain locations. So this new recycling legislation is, I think, relevant and important. Affected industries may include manufacturers of batteries containing products, and retailers with batteries, lithium-ion batteries. There's a series of DNR rules that have taken effect in this past year, 2025. So I'm going to touch base on those to make sure that you're aware of these rules that are in effect, and many of them are in effect as of July 1, 2025. I'm just going to check my rules here. So this first is air pollution control, NR 439, but it's actually in 439 you may know to be reporting, record keeping, testing, inspection, and compliance requirements, but it actually covers more things. For example, NR 400 is definitions have been added to. NR 419, organic chemical manufacturing. NR 462 is industrial and commercial emissions. And then NR 484 is kind of a cleanup rule. With regard to chapter NR 500, these are solid waste management rules. They have an effective date of July 1st, 2025, and it deals with statewide materials recycling program. And the next rule deals with landfill solid waste management fees, financial responsibility, and reporting requirements. And this is actually a very broad regulation that covers NR 500 through 599. And it was effective October 1st, 2025. The NR 600 series is probably what we're most concerned about. And this incorporates federal hazardous waste regulations um, and related to updated test methods. This first rule was effective July 1st, 2025. The second, modifying and expanding the Universal Waste Program, was effective July 1st, 2025. And then the third regulation has to do with covering NR 660 through 679 and its technical corrections to the hazardous waste regulations and program. We're going to shift a little bit to the federal issues. So Trump's administration has overturned what's deemed to be costly California vehicle mandates. And what this rule in California sought to ban the internal combustion engine in new passenger vehicles by 2035. That has been overturned, and it was believed to be an unrealistic number of zero-emission trucks and establish unattainable emission standards for heavy-duty trucks as well. At least 11 other states had adopted these California regulations, and so it was going to sweep the United States and affect all automobile manufacturers. The waivers had been revoked, and the law cannot be reinstated by the EPA under a future administration. I don't think that's true because the new president, whoever that may be, can do probably what he wants to do. US EPA proposes repeal of costly power plant regulations. This was driven by Lee Zeldin, and he announced the rules that they're reversing targeted coal, natural gas, and oil-fired power plants, basically fossil fuels. And the concern was that it was harder to generate affordable, reliable energy in the United States, and that rule has been repealed. Also, EPA announced two major rulemaking actions: the repeal of the greenhouse gas emission standards for fossil fuels, electric generating units. That was signed into law June 11th, 2025. The second rule was the repeal of the national emission standards for hazardous air pollutants for electric utility generating units, and also known as the mercury and air toxic standards, MATS. So that required an 86% reduction of mercury and air toxics. And that has been repealed as well. Effectively, the agency is proposing to repeal all greenhouse gas carbon dioxide emission standards, clearing the way for increased use of fossil fuel fired power plants. And this was initially promoted by the Obama administration under the Clean Power Plan. And the Supreme Court overruled the Clean Power Plan and rejected it, saying that the rule misused the Clean Air Act to manipulate Americans' energy choices and shift the balance to the nation's electrical fuel mix. So that was done by the Supreme Court. So Administrator, I don't know if you know this, but Lee Zeldin is being considered to replace Pam Bondi. I don't know if that'll happen or not, but I find that, kind of interesting. Trump must feel he's doing a good job. He made a statement that the rule will not eliminate mercury or toxic standards, but rather remove gratuitous requirements added by the Biden administration. And so they took a shot at mercury and air toxics for power generating plants. I'm going to drop down to the U.S. Supreme Court Thames NEPA review. So this has been a big issue and probably one of the primary targets of the Trump administration um, in Lee Zeldin through the EPA. But it requires permitting agencies to analyze environmental impacts of the proposed project, primarily by preparing an environmental impact statement. This had to do with a railroad. And the way they were challenging this railroad project was that it was not only the impacts of the railroad, but also the activities upstream and downstream of the railroad project, including oil well drilling and oil refining sites. And so they said that the environmental assessment or impact statement had to include the environmental impacts of these upstream and downstream activities. Um, the justices agreed unanimously on the result, and it was titled the Seven County Infrastructure Coalition versus Eagle County in Colorado. So NEPA has been, confined, and it is limited to address the environmental impacts and effects of the project at hand. Now we're going to move into well, there's a couple other issues I wanted to address. We had talked, I think, previously about the public trust doctrine and how that was being impacted by two cases in Wisconsin. One had to do with a Shorewood case called Village of Shorewood versus Paul Florsheim. And this fellow walked his dog on the shoreline of Lake Michigan, and he was challenged, and he received a fine for walking his dog below what he believed to be the ordinary high water mark and the water's edge. And so in Wisconsin, the belief was that the public trust owns land up to the ordinary high water mark. He lost that in municipal court, and now they've challenged that ruling, and it'll probably go to the state Supreme Court with regard to what is actually the limits of the public trust doctrine. There was a similar case in Michigan, and Michigan held that you have to be on the wetted part of the shore, and that would be within the public trust. There's another case called, let's see, Thomas Rees versus the DNR. And this has to do with a flooded farm field along the Rock River. And my understanding was there were airboats that went out into the Rees's farm field. It was flooded by the Rock River, and they were carp fishing. And so Rees sued the DNR for not enforcing the public trust doctrine. And his argument was, if it's flooded, it's part of the public trust doctrine. Now that is currently at the Wisconsin Court of Appeals, District 4. And so these two cases are going to hopefully clarify what's in and what's out of the public trust doctrine. And we'll continue to watch these. I'm at the bottom of page 5. I'm going to review, at least briefly, the Wisconsin Legislative Council Amendment Memorandum. And this is very well done. It was a very detailed memorandum, and I provided the entire memorandum to you. It's about 15 pages long. And it deals with Wisconsin Act 131 with regard to PFAS and the programs that the Wisconsin legislature has passed. Now, I really have questions about this program because it effectively circumvents the spill law and certain enforcement mechanisms that the DNR has. And so it's the legislature taking authority away from the DNR, but then adding grant programs that the DNR has to administer. And that's going to be quite a challenge. It's very complex, as you'll see as we walk through this program. But PFAS is a huge problem for not only Wisconsin, but other states throughout the United States, and even in Europe and other countries. What I find interesting is that Georgia and New Mexico and some other states have almost identical programs for PFAS, grant programs and regulations that affect who's responsible for cleanup. And so this will be interesting to see how it evolves. My guess is that there was initially Act 131, and then as it went through the public hearings and comments, there developed a subsequent memorandum, an amendment to the program, and that amendment basically totally revamps the initial 131 legislation. But we'll walk through it, and I'll just give you some highlights that I came to mind for me as I reviewed the bill. But I'm sure that there's going to be a whole lot more information on this as time prevails. So it basically says initially that DNR's regulation and authority is under the spill law in Chapter 292 of the Wisconsin statutes. And it deals with 292.11, basically, where a person caused the contamination or possesses and controls as an ownership has responsibility for remediation. That can result in some very harsh requirements, particularly under PFAS, because PFAS may not have been caused by or even anywhere associated with the current landowner. So there's an innocent landowner provision in this new legislation. And it also develops funding for this program, about $130 million, which sounds like a lot, but it's woefully underfunded, I'm sure. But anyway, it was initially started in 2023 under Act 19, where it was part of the Biennial Budget Act. However, there was no appropriation for the monies to actually be used. So it consists of $110 million transferred from the state's general fund, $15 million transferred from the environmental management program, and then other segregated funds and settlements out of enforcement to make up the $130 million. So this was 2025 Assembly Bill 131, and it establishes various programs and requirements to address PFAS contamination in Wisconsin. And it really attempts to cover all sources and existence of PFAS. There's a municipal PFAS grant program for municipalities that deal with drinking water and also private landfills. It creates an innocent landowner grant program. It has to do with a good deal of this has to do with land spreading and historical land spreading as a form of treatment for biosolids and wastewater residuals. It also addresses PFAS as a result of fire department using foam for firefighting, public use airports for the use of foam in municipalities, and also brownfields. It addresses solid waste disposal facilities that are that have accepted waste in terms of landfills, and it deals with the treatment and management of leachate from those landfills. So it's very comprehensive. But then it provides exemptions for Wisconsin's remediation law. So on one hand, it provides some funding. On the other hand, it provides exemptions to DNR enforcement and clearly cleanup obligations. So the bill prohibits DNR from requiring a grant recipient to take action under the state's remediation law. However, if the grant recipient does not proceed fast enough, then they can withhold the grant funds or rescind them. It modifies DNR's authority to take action under the remediation law with respect to certain other property, prohibits DNR from preventing, impeding, or delaying the construction of a public works project on the basis of PFAS. That's very interesting. I don't know how they're going to get around and do that. It requires DNR to follow certain procedures, prohibits DNR from taking enforcement action regarding cleanup, and it directs DNR to respond in a timely manner. That's going to be a breath of fresh air. The bill specifies that DNR may contract with a third party, so they can use third-party consultants or contractors, and provides regulatory flexibility for certain utilities to address PFAS. So what I find interesting is they're starting to acknowledge that DNR does not have to do all this enforcement, but that they have regulatory flexibility, which tells me if it's not that bad, then it's not a crisis in terms of cleaning up quickly. It also allows utilities like the electric company or the water utilities to use the ratepayer funding. So people are paying rates for electric or water use. That funding can also be used for PFAS cleanup. And there are co-pays in this program as well. It allows certain water and sewer utilities to commence projects to respond to PFAS-related public health, and it provides the Clean Water Fund and the Drinking Water Fund dollars for PFAS cleanup as well. You can get around first obtaining approval from the Public Service Commission if you follow certain steps, and one of those steps is notification. It also, I'm on page 9, it also directs DNR and the University of Wisconsin system to enter into a memorandum of understanding to conduct a number of studies, create an interactive map showing all available PFAS testing data. That's going to be interesting. And studies relating to the cost, feasibility, and effectiveness of different methods of treating, destroying, and disposing of PFAS. Requires a cost-benefit analysis, which is, generally not heard of. It's not, the environment is not a cost issue, but here it says a cost-benefit analysis of different options for disposing of biosolids and sewage sludge. I find it interesting because for years we've been disposing of biosolids and sewage sludge in landfills and also on farm fields, and that's being recognized in this new legislation, and there are exemptions to enforcement on that. It also provides for mitigation of PFAS migrating into the Green Bay with the Wisconsin and Mississippi rivers and their tributaries, and additional studies as approved by Joint Finance. So Joint Finance can dream up some studies that will be funded under this program. And the DNR has to report to the legislator every 6 months for 3 years following enactment of this legislation. So DNR has to generate a report, and I'm sure that's going to be by committee, on their progress. It provides authority allowing DNR or contracted third party to begin response and remedial actions. And it also provides for interim actions to mitigate the migration of PFAS contamination, which is a good thing. And DNR has the authority to do these cleanups where a responsible party has not been identified. And there's a brownfields program as well within this legislation. It has the UW Board of Regents providing grants to laboratories who are certified or who wish to be certified, which for PFAS testing. And it provides for DNR to prioritize various projects. And there's various factors that are included. It provides financial assistance of the Safe Drinking Water Loan Program for public drinking water and the Clean Water Fund for wastewater treatment. It specifies that the cost of filtration devices and up to 2 filter replacements are eligible under the Well Compensation Grant Program. So it addresses not only public water systems, but private water systems and private wells under the Compensation Grant Program. So it's really very comprehensive. I can't imagine they need 130 billion instead of 130 million. What really modifies the program is this, I'm on top of page 10, the Assembly Substitute Amendment number 2 makes significant modifications to this initial act that's being proposed. So it substantially revises the bill's exemptions under the remediation law and other exemptions, generally removes provisions limiting DNR's enforcement rights, and addresses even community water systems. Community water systems are small systems, basically with 1 or 2 wells. And it removes or affects enforcement authority and replaces the municipal PFAS grant program with a structured community PFAS grant program. So instead of a municipal, it's a community PFAS grant program. It deals with replacing or treating wells contaminated with PFAS through the well grant program. Is there a question? It creates a new grant program for airports and certain industrial properties, establishes requirements relating to land spreading of sewage sludge, exempts municipalities with regard to PFAS contaminated brownfields. These are all good things. The substitute amendment generally retains the following provisions of the bill. It still provides regulatory flexibility to the DNR and to certain utilities, authority and requirements for various studies under the UW system, changes relating to priority ranking, and requirements relating to certain well testing. I'm at top of page 11. There is exemptions on the remediation law. It exempts the following people: a person contracted to spread wastewater or industrial waste contaminated by PFAS if they are spreading it in substantial compliance with their applicable license or permit. So this allows the spreading of PFAS contaminated materials on farm fields, as long as they're within their license or permit, which probably doesn't address PFAS at all. It just addresses the rate at which and the volume at which it can be applied per acre. A person who owns property that is used primarily for agriculture or residential purposes, upon which wastewater or industrial wastewater contaminated by PFAS was spread. So this is an exemption for application on agricultural or even residential properties. The exemption does not apply to a person who caused the discharge of PFAS. So this deals with essentially innocent parties. Non-compliance with permit conditions are unrelated to PFAS may not be construed to affect the applicability of the exemption, which means a person who owns industrial property is exempt unless they cause the discharge or the PFAS. And it also approves, as I mentioned before, immediate actions and interim actions required by DNR with respect to PFAS on a property to control the discharge. It exempts publicly owned and operated fire departments that responded in an emergency that required to use PFAS foam. Does not apply to training conducted at public use airports. The exemptions apply to municipal waste landfills and that have contaminated leachate and at publicly owned treatment works. The wastewater plants are exempted. It applies to exemptions for waste landfill installs and operates a DNR-approved leachate pre-treatment system of all leachate for PFAS either by December 31st or sooner. December 31st, 2032. So that's 6 years into the future. There's an exemption for treatment of municipal landfill leachate. A person that owns, leases, manages, or contracts for property. I think contracts for property is a purchase agreement for the property on which PFAS contamination did not originate unless the person owns, leases, manages, cause the discharge. There's all kinds of exceptions, and they're pretty complicated. The substitute amendment defines immediate action. It basically spill response. It defines municipal waste landfill, which includes privately owned landfills that accept municipal waste. But it's not one of the following. Solid waste disposal facility designed exclusively for the disposal of waste generated by a pulp mill, paper mill. So any industrial monofills are excluded from this program. Hazardous waste disposal facility is excluded. The exemption does not apply with respect to the discharge occurred at the location rather than in connection with the disposal of leachate. So it's pretty complicated where the exclusions apply or not. They mention this often. They say the substitute amendment specifies that the exemption also applies to the owner or operator of an animal product or food processing facility that spreads wastewater or industrial wastewater contaminated by PFAS on the land. So certain land application is permitted. They talk about a general permit and an individual permit, and they say that it does not apply to an owner of business or entity that does any of the following. Owner operates an industrial or manufacturing facility that has used or is using PFAS. So the exemptions don't apply in the grant program, just don't apply. It does apply when the PFAS is coming onto your property from an offsite source. And there's a community PFAS grant program, which replaces the municipal PFAS grant program. It's now termed community. Under the substitute amendment, a municipality must pass a resolution or enact an ordinance authorizing the municipality to enter into a financial agreement. This is for the grant program. And it also talks about the copay. And the copays are all over the map. There's some that are 20% and some are 40% copay. So I'm sure they'll have to work through the details there. It also allows the creation of a new public water system for connecting private wells owners to an existing public water system. So if you have a community system, it will fund the connection of the community system to a public system to address PFAS. It also deals with sampling of high capacity irrigation wells, sampling of PFAS in wastewater, sampling of PFAS in biosolids, sampling of PFAS in leachate, and also designing, purchasing, and installing on-site treatment systems that remove PFAS from leachate from a municipal landfill. The well compensation grant program is used, and that's always has very little money in it, but it's predominantly to address low-income landowners for replacing, reconstructing, and treating contaminated wells. So there's going to be a need for money into the well compensation program. It also addresses non-community water supplies, which would be probably private wells, and it includes public, private, and tribal elementary and secondary schools, a licensed child care center, and a licensed child care provider. And there's up to 100% reimbursement for those entities, the schools, the child care center. So that's probably a good thing. It deals with airport and industrial processors, financial assistance. The substitute amendment, this is all under the substitute amendment. So you can see that it has, that amendment had a remarkable modification to the original act. I'm going to try and skip forward. There are checks and balances. DNR can reimburse eligible expenses, but they also can terminate a grant program if not enough progress is being made. So the new general permit program has to take effect in 120 days after the bill takes effect. DNR will really have to scramble to put that into place. I'm on page 19 now. The substitute amendment retains a requirement under current law to deny a claim if the claimant or other person would directly benefit from the claim. And what this is aimed at is if they intentionally introduce PFAS contaminants. A municipality is exempt from liability under certain requirements under the remediation law, and specifically brownfields. PFAS and PFOA are currently regulated under various Wisconsin laws, and it references the Groundwater Protection Law, Chapter 160. It provides for 10 new DNR positions to implement this program, but they cannot, none of those 10 positions can be used for enforcement. I think that's enough on this 131. I'm going to move down to page 20, and I want to touch on the this issue that I mentioned earlier, that of what's called forum shopping. So the EPA, the Trump administration, and the Department of Justice brought a case for compliance waivers for air toxics. Now, mercury and air toxics applies to a number of different facilities and permits. And the one case that is in Texas, and it's being moved and pending before the U.S. District Court in the District of Columbia, but it initially was filed in Texas because they were trying to find the most favorable forum. There's another case that I want to touch upon, which is the federal 2.5 PM standards, and those are in litigation as well. And the issue is, how do the states designate attainment and non-attainment? There are a number of deadlines that were missed. There was originally a 2024 timetable, and states had to designate areas within their state that were in attainment or non-attainment. Most states did not designate that. It's like 6 states out of 50. And then after they designate these attainment and non-attainment areas, EPA has 120 days to do a response letter. That is not taking place. And there's litigation filed on November 24th, 2025. That's fairly recent. And the case is called the Commonwealth of Kentucky versus EPA, where EPA asked the court to set aside the new 2.5 PM standards. And the basis of that litigation is the EPA is saying that Biden EPA failed to conduct a thorough review of the Clean Air Act requirements. So those cases are pending, and they're going to have significant impact, as well as the ozone designation. That's all I had for today. I'd be interested to have feedback back on the format of this. Before, I was trying to list everything, which was somewhat challenging because it was really too much to cover. And today I was trying to list the highlights as much as I could. So if you want to shoot me an email and tell me what format you prefer, that'd be helpful. Are there any questions or comments? We're just about out of time. I guess there are none. I appreciate you attending today, and hopefully we'll have a fourth environmental issue session. Thank you.
Thanks, Don. Thanks everybody for joining us, and I'll send out the recording to everybody who attended and was unable to come on, and I'll send information. We are scheduled for Friday, June 5th. So mark that on your calendars, and I will send any updates if we have any.